At the moment, we need to be very clear. The Minister spoke about all of those who'd lost out through COVID payment, all of those on illness payments, all of the people who would be covered and who are still going to be protected. But there's a caveat on their protection. They are not automatically protected. They are only protected if they go through a process which we rightly described in this House as elaborate, as off-putting and as chilling, in order to declare themselves to be a relevant person. And what we have seen very clearly, exactly what we warned has happened. People have not declared themselves as relevant persons. We have, at the moment, look at this, the chilling effect. Since July of last year, only 700 people have applied to be considered as a relevant person. That's 700 people, despite the fact that just even as of last week, 449,500 individuals were in receipt of the PUP. So we have a huge gap between those who would be eligible potentially for this protection and those who actually have this protection. And the reality is that when the 5K limit is removed, a huge number of people will not be declared as relevant people and will not access the protection that they need. And that has been entirely avoidable. These amendments, Amendments 3 to 6, give you, Minister, the opportunity to address the problems that we knew would happen at the time. If you accept Amendment 3, then the speech which you gave earlier will in fact be correct, in a way that it wasn't, unfortunately, because you spoke about those who have protection, those who are entitled, but you left out that piece about the declaration, and that is the issue here. My amendment number 3 would mean that the protections which will stand under this legislation during the emergency period would apply in relation to a tenant and the relation to a tenancy of a dwelling where he or she is a relevant person, and as a consequence thereof, there is a significant risk that the tenancy of the dwelling will be terminated by the landlord.